not sure why the one case has like so much more
Dance one?
to it than the dance invasion.
I can edit it.
Oh, okay.
Okay.
Everybody ready? All right. Well, my name is Christopher Drummons. I want to thank you all for meeting with me today to try and get a resolution here. Before we start, I just want to make sure I have everybody's name correctly and the parties correct. Could you state your full name for me?
Joseph Nero.
Oh,
Yeah.
that's fine. How about you?
My name's Erin Burton, counsel for Mr. Lewis.
Do you have any preference about what you want to be called?
Attorney Burton is fine. Or Erin, whatever you decide.
How about you, Joseph?
Joseph's fine.
And could you state your full name?
Yeah, my name is Michael Idea,
How would you like to be called?
just Dr. Idea.
How about you?
I'm Morgan. I'm counsel for Dr. Idea. Morgan's fine.
Again, I'd like to thank you all for coming into mediation today. I assume your counsel has told you what mediation is, but just in case, I'm going to go through a small rundown about what we'll be doing. Mediation is an informal process where the third party, the mediator, will be here to try and help you to the two parties come to a resolution. I'm not a judge or I don't have any authority, so I can't make you do anything. But I'm here mainly to facilitate between the two parties and make sure things run smoothly and effectively. Just a couple of ground rules that I ask everybody to adhere to. Just try not to speak over each other and just try not to interrupt. What I'm going to do is the opposing counsels are going to have their time to speak first to give their side of the argument, and then later on I'm going to caucus, which means I'm going to separate and meet with each party one-on-one. And that's how it's going to go to the end of the mediation. Are there any questions?
No.
Now, before we begin, I sent all the councils a agreement to mediate, but I have an official copy here, so I would just like y'all to sign it if you would. That's all you have to sign.
Oh, you did.
If we reach an agreement, I have another form at the end. Well, we'll also kick in. All right, so I'm going to start with the opposing. The initiating party. So, Joseph and your counsel, if you'd like to go first.
Okay. Well, I was hired by Mr. Idea to open up our DNA testing clinic, and I was the lead director in charge of getting this clinic and laboratory on the off the ground here. I was hired under a 1-year annual contract with a salary of $120,000 that was to terminate 1 year from the day on which I signed it, which was July 1st, 2012, and a 6-month notice is required for termination for any reason other than for cause, which is the specific language. Basically what happened was as we were filling out the paperwork to set up the laboratory, we ran into difficulty securing approval from the state of Ohio for permitting. According to the state, you need to have $100,000 in cash reserves in case the company is to run across hard times. And we only had $75,000. In my professional opinion, and for the experience that I've had in this industry, I thought that $75,000 would be enough. So I filed an appeal to have the state of Ohio waive the requirement. in which they denied it, and the amended application essentially resulted in our laboratory not being adequately funded, not being approved, and as a result, Mr. Idea, terminated my employment and pulled the plug on our laboratory here. What I'm asking for here is, I'm a little angry and kind of surprised, but I'm looking for six months' pay, which is $60,000. Considering that I needed a 6-month notice of termination, so I feel that was fair. That's what I have.
And, I'm gonna go to the opposing counsel.
Okay, so most of the stuff he said was correct. I hired him to be the director of the new genetics laboratory that I was setting up. We signed a 3-year employment contract. He'd be receiving $120,000 a year. However, why I feel I don't have to pay him any of the severance pay is because he never alerted me to any of the issues with the financial reserve. This was never brought to my attention, and I had no opportunity to respond to any of these issues. So I think it's a joke that he's asking for any type of severance pay because he didn't do what he was set out to do. One of his responsibilities was to secure all the necessary state licenses. So I don't feel like I owe him anything. And that's pretty much it.
Okay, so I guess what we're gonna do now is, we're gonna go into caucus. Before we begin, I'll let each party have maybe 5 or so minutes, so you can come up with your arguments, and, we'll be back here in a few minutes. We're going with the initiating party.
Okay.
You guys have a couple minutes.
Yeah.
I don't know if I can stop this or
Okay,
That's cool.
we'll you guys just get on
Just
the
keep it
screen
rolling.
and then-
So, do we need to meet? Is that what you are saying?
We're gonna
gonna
meet with
be-
them first, so you
Okay.
guys can go.
You guys want to?
Okay,
Yeah.
all right.
It's early in the morning.
I know.
So, Mr. Lewis, what would be your main goals?
Well, like we said before, I want to try to avoid litigation here because I believe that we're not going to be able to get a substantial amount of money if we go to litigation because of attorney fees. I think that with the amount here,
It'd be like, I estimated that as like $25,000.
So- so yeah, I think we'll be a little short there.
Okay, I just wanted to tell, I think that we can, I'm anticipating that you'd be able to get your $60,000 because it's pretty open and shut case in my opinion. Termination clause is pretty clear, so I'm gonna go ahead and go for the $60,000, and also if you would like to claim something for breach of contract, we could also talk about that, maybe use the breach of contract threat as a tool to get the $60,000. Instead of starting with 60 and then getting negotiated down, we can start with a higher number with the addition of the breach of contract numbers, and then work our way to the $60,000 goal.
Okay.
If you,
Yeah,
Think
if
that's a
you
good
feel like
tactic?
that's a good tactic. I think the lowest I'll take is 30.
okay, so lowest is 30.
So at least we have an idea, just because if we go to litigation and I get 60, which is what I'm owed,
Mm-hmm.
it will be around 30, 35
Okay,
after fees, so
okay.
that could,
My negotiating style is usually to start high, but we could also just start with an honest number and stick by it the whole time.
whatever you feel is best.
Which one?
Trust your judgment.
Okay, well, let's see how they do.
Yeah.
If they seem like they'll work with us, we'll start with a high number.
Sounds good.
We'll send them in now.
Yeah.
Go ahead. Yeah, I was just kidding.
wanna tell me that you couldn't tell me,
Yeah, my client, he doesn't really feel that he's at fault here. He just believes that, Joey should have told him about this and that he had the right to fire him because, under Ohio law, cause for termination, we feel like we can meet all the elements of that.
Mhm.
Do you wanna-
Yeah, well, the thing is that I wouldn't have been able to get the extra $25,000 of funding anyways.
We don't want
We don't
them
want
to
that
know.
happening to them.
We don't feel comfortable settling for less than, or for more than, what did we say,
Yeah.
35,000?
You know, we would like to settle the matter, but my ceiling is 35,000.
Yeah, I'm a little nervous to take this to court. I feel like they might have jury sympathy and they also might be able to poke holes in my theory. So we'd rather have it settled here. We don't really want this to go to trial just because we're not sure if we'll win, but we don't want to pay more than Dr. Idea has discussed. Anything else?
Guess it says that, oh yeah, I did start up another lab. It's doing really well. And
Yeah, we don't want them to know that either.
So you terminated him, but you didn't adhere to the 6 month
Correct.
agreement, right?
But we feel that, in this case, we didn't have to because Dr. Idea had cause to terminate him. Under Ohio law, there's 4 elements to that, to prove that case, and we feel like we can meet all of them. So, yes, according to the contract, we did not follow the 6-month rule, but it was extreme circumstances, so we think that it was justified.
But you still don't wanna go to court just because,
No, I feel that it's just up in the air as to if we would win in court, so we prefer to get this done today.
so you said your ceiling was no more than 35, correct?
yeah, that's the very most.
And are you ready to give them that number right now, or?
I think we'd like to talk to them, hear what they say, but we don't really want them to know that's our limit. We'd like to pay less than that if possible, but.
So you want them to come up with the offer first, and then, I'll meet with you again?
See, they actually did offer, didn't they? Because he won 60,000.
Yeah, did he give you a number?
No, we haven't spoken yet, that was just me.
Okay, yeah, we can,
Okay.
So
we
then-
shouldn't counter what I.
yeah, let's see what they say and then we'll,
I'll keep that number private.
Okay.
and then-
okay, thank you.
All right.
All right, so, is there anything that you wanna tell me now that you couldn't tell me during the initial opening?
As in facts or maybe an offer? Are we ready to put offers on the table?
Let's start facts first, and then we can talk.
Okay, no, I think we pretty much told everything. We estimate, I guess the only thing would be confidential wise, and this won't be told to the other party, right? Maybe we estimate like a $25,000 fee for litigation and expenses for attorney fees if we do move forward, so we would really prefer to settle now. So the goal is settlement, and we'd like to at least get 60,000, so I'm gonna try to negotiate towards that goal. And that's pretty much it.
Now, if you were to go to court, how do you feel your chances would be?
I feel like we have a very strong case. I've done a lot of litigation, and this is pretty open and shut. The termination clause is very clear in its language. I've tried a lot of contracts, especially employment contracts. That's my specialty. I think I'm very confident that we would win this case. Now, I don't want to drag my client through litigation and all that stress and hassle, but I think we have a very strong case. So we're gonna pretty much stay firm to that 60,000 range, because I think that we would at least get that plus some breach of contract fees if we went to trial.
Your first offer, 60,000?
We wanna say 80 because we're gonna sue for $20,000 for breach of contract in addition to the 60,000 that he's already owed for the employment contract. And then the 20,000 is for the hassle of going through the breach of contract through the courts and such, just to cover his expenses.
So 80,000 is for breach of contract and,
Yep.
Yes, 20,000 for breach and then 60.
There was some reliance as well, because I'm from Chicago, so there's some
Yeah, he's put a
reliance
lot of
costs
money into
and
this.
moving here from.
He's put a lot of money and effort into this.
well, if you could send the other party in, I'll present your offer. So Joseph has made an offer. They would like to stick to their initial offer that they made in the beginning, which would be $60,000, and then they want an additional 20,000, so a total of 80,000.
I will tell them this then, because this wasn't said before. That thing they aren't taking into account is I purchased $90,000 in business equipment for this failed venture. And I talked to several different people, and the most I'd be able to get for it would be $60,000. So there's a $30,000 loss right there. So they're gonna have to look at that as well. And I've already paid him $70,000 in salary for, once again, no business. And I've put over $105,000 in the business as well. So 70,000 in salary I've paid him, and then another 105 in investment in the business. And then I'm gonna lose 30,000 on the equipment I bought. So they're gonna have to look at that. And
All those numbers, things I can share with them?
yeah. So I guess ultimately our offer would be, given all the money that I've paid, 25,000.
I think that's a reasonable offer. I mean, while we don't want this to go to court, we think that
Tell them, you know, you can,
drag it on.
yeah, you tell
I
them
think
that,
that Mr. Joey will, we think he might go back to Chicago if we take this thing to trial and make it long enough and drag it out. So, and also my client's already paid him 70 grand for his salary and he's done nothing but drive the company into the ground. So I think that their offer of $88,000 is a little bit ridiculous, especially when we have case law on our side. So, did you want to offer 25,000?
yeah.
Okay, yeah, that's the number we would like to give them.
Okay, well, I'll present your facts to them, and then I'll give them your offer, and then I'll let you know.
Thank you. This computer, so it's all on the screen.
So, I presented your offer of 80,000. They rejected that offer. They wanted me to share some facts with you, which I've been authorized to share. So Mr. Idea said he already paid you 70,000 in salary, is that correct?
Did he pay 70,000? What was the 70,000 for?
It
did
was
he say?
60,000 in salary.
Which was dictated under the contract, anyway, so that was money he was due, that's not really on the table at this point.
He also stated that he spent about 90,000 in business equipment. I assume for the lab. And if he were to resell it, he could only get 60,000, so because of this whole incident, he'll be losing about 30,000. And he also said that as a total investment for the lab, he spent $105,000.
Again, I don't really think that that money is of consequence because he decided to go to this business opportunity and sometimes you get burned on business ventures, but, we'd be willing to come down a little bit.
Okay, well, he gave me a counter offer that,
Okay.
they are offering $25,000.
I would confer with my client here, what do you think about that offer?
That's a little, so.
Yeah, I think so too, but it's your duty to make the decision to offer, so.
Yeah, I think probably definitely up. What was if we went back at like,
I think we could counter offer with like,
45, 50-ish?
I was gonna say 60, 65.
What are we at right now? We just came in at 80.
You came in at 80, they rejected, and they came in at 25.
So we're way apart.
Just a little bit.
I don't think we should offer with something as low as 45, especially since
Okay.
we're relying on the fact that the termination clause states.
60.
Yeah. I mean, the money that he's out, that sucks, and that's why we're willing to come down, but I still don't think, he signed a contract.
And he told me specifically that he wasn't willing to back anything more than $250,000. So that's why the company failed, because even going to him for the extra 25 grand, he was pretty clear that he only wanted to invest 250,000, and that was the budget that I was left to work with. So him saying that this falls on me isn't completely accurate, because the budget that I was set up with going into it really wasn't going to
I would
work
just-
regardless. So I think 60 is what was contracted, and I think that's fair.
If you would just explain, with your authorization, obviously, Mr. Lewis, but if you would just explain to the other party that, the termination clause states that if it's not for cause, that he's owed the 60,000, period. So unless they are arguing that my client was terminated for cause and not because the business failed, which would be hard to prove in court because obviously the business failed, we're owed that money, period. So unless they have some argument for cause, we're gonna stick pretty true to the 60,000 at least. The breach of contract we can come down on.
I will ask them about the termination for cause, and I'll present your offer of $6,000.
Thanks.
You went down to
Do you have a number
85.
for us?
Yes, I do have a number for you. They rejected your offer of 25,000, so they made you a counter offer of 60,000. So they went down.
All right,
Do
so-
they have any other things to offer us?
They were a little concerned about your determination. I didn't share this with them because you said you terminated him for cause, but they would like to know. They feel that there wasn't any cause.
Right, well, I'm not sure if they know about the Ohio law, but for cause has 4 elements. Should we tell you them?
Yes, just a second. Whenever you're ready.
Okay, an employee engages in intentional conduct. That's the first element. Within his or her control is the second. And the third is it causes harm to the employer. And the fourth is the harm to the employer is substantial. So if all those are met, my client or anyone in Ohio is allowed to terminate for cause without being punished. And I think we have a good case for all of them. So I think that once they hear that, they might make a better offer. My client really doesn't want to go over 35,000. That's going to be the top. We're not going to go over that. We're willing to offer maybe some. I don't know if you're comfortable with saying it already, but
I don't think we should go there yet.
okay.
I'd
We have
say
some
that'd be
other-
the last, that'd be
Yeah,
the
don't
last
share
thing
that
I'd
with
offer.
them. We have some other things we're willing to offer, but right now, we'd just like you to tell them the case law and tell them that 35 is our max. Are you
Yeah.
comfortable with that?
I mean, would you tell them that we'd be willing to, drag this out and the attorney's fees that would go along with that could make me think twice about it.
Maybe just remind them that we're willing to,
Because we
Drag
think we
this on
can do
for a
the
while.
case. So,
I know we said we prefer not to, but we don't want them to know that.
But you want me to tell them you're willing to go to court?
Yeah.
and see what they think about 30,000, given the type of case we have and the money I've already spent on him and the business.
I'm authorized to share your 4 calls, correct?
Do you not want to disclose that 35 is your max? You just want to offer 30 right now?
Yeah, just offer 30.
Yeah, 30, and then let them know that we have a good case.
What you got for us?
All right, so, I asked them about 4 calls, because you asked about the termination. The attorney explained to me that 4 calls in Ohio has 4 elements. The employee engaged in intentional conduct. The employee is within the conduct and scope, if I'm not mistaken. That employee causes a harm, and the harm is substantial. So they believe they can fulfill all 4 elements, and they believe that they have a strong case. They also are willing to drag this into court, but they did make a counteroffer, if you'd like to hear it.
Sure.
So they're not that willing to drag it into court.
They're willing to drag it into court, but they're trying to be reasonable. So,
Okay.
the counteroffer is 30,000.
Well, I mean, I'm glad that the other attorney doesn't think that I know the elements of for cause, which I've been doing employment law for 62 years now. So, I'm very aware, sorry, I don't think that they would be able to prove the 3rd element, which was the, harm was caused by the employee's conduct, because the employee was very willing and working, but the lab wasn't able to meet the statutory requirements for the funding behind the lab. And that's the reason the business went down and my client lost his job, not for cause. But that aside, we're willing to come down on our offer. I think, Mr. Lewis, if that's included.
Yeah, that's fine.
What do we think about maybe, 50,000?
Yeah,
45?
45.
What do you think, 45?
Let's do 45.
45 sounds good.
See if they'll take that.
And
So we
make
don't wanna
sure,
haggle too much back and forth.
yeah, let's tell them, I think we should tell them this is our last and final offer. Because I don't wanna go much lower than 45. Now, we
I
can
mean,
always go back on that
I
if we
think
want
too,
to.
like, they're gonna have a hard time proving the intent. I'm not an attorney, but
Absolutely.
the intentional conduct I don't see there, because
Mhm.
it's not like I intentionally tried to get this business to fail. I filed an appeal with the state of Ohio and tried to get it waived, and by no means was I intending to tank this business.
Right.
So,
I think they'd have a very hard time.
yeah, I think they would definitely struggle to get all those elements met, especially in front of a jury.
I will let them know this is your final offer.
Yes,
Okay.
And if I meet with them and they come back with the counteroffer, you still want to hear it?
yes.
And I will address the 2nd and 3rd elements, intent.
It's a fine leather jacket you have there too, sir.
Thank you. So, the opposing party they wanted to speak about the elements for cause. They believe that you would have a hard time proving intent, and the 3rd element as well, the harm to the employer.
I think the 3rd one is definitely, his
That'd be the
company,
easiest.
yeah, his company is you would say ruined, right?
Yeah.
Because he didn't get funding, so I think that, the third element and the fourth element are clearly met. Are you talking about the first element where it was intentional?
Yeah, intent.
I mean, he deliberately kept it from my client. I don't know how that could have been an accident or unintentional. So, I mean, it looks like it's leaning in our favor more than theirs. I mean, it might be a bit of an argument, but I think ultimately we would end up proving the four elements. So, did they make another offer?
They believe they have a strong case as well, but they did make an offer, and this one is their last and final offer, so. But if you give them a counter offer, they said they would be willing to listen. So their last offer is, $45,000.
Seems a little bit more like where we want it to be. Do they have any other requirements, or is it just the money?
Just the 45,000.
Does Joey have any, did he say what he's gonna be doing in the future? Does he have a job lined up?
We did not discuss that.
Okay. Well, I mean, my client really does not wanna pay over 35,000. That's our final offer. Are you willing to say that now? Dr. Hardy? They made a final offer. We
Yeah, I
can offer them
mean-
35,000 if you don't wanna pay more than that. And we could discuss, I mean, I know you think Joey is an excellent scientist. We could discuss maybe giving him, some room to work in your new lab, if you're comfortable with that.
So you go offer 35, see what they say, and then offer them, right?
I mean, their final offer was 45.
Okay, so,
But you said they're willing to listen to a counter.
Yes.
I mean, we went up $5,000 since our last offer. I mean, we could keep that in our arsenal if you don't wanna disclose it yet.
yeah, I mean, because,
They're probably gonna wanna meet us halfway at 40,000. And I know you just don't have the means or the
Seconds,
drive
yeah.
to do that. So. Do you wanna offer them the 35,000 and maybe discuss what he's doing? Do you wanna bring them in here, or do you wanna still meet separately?
I'm going to offer them, I'm going to give them your offer, and then I'll bring you two together after that.
Okay. Did you wanna offer talk about the job, or do you just wanna go with 35,000?
we'll go with that, and then, why don't we meet all together then after you ask them that?
So don't disclose the job yet?
No, we won't.
Okay, yeah, don't
Disclose
disclose
that one,
his lab
all
job
four of us
offer.
make them.
Okay, so 35?
Yeah.
Okay. Final offer. Thank you.
It's taking a little longer than I thought.
Alright, so they have a final offer as well. They rejected your offer of 45,000.
What did they say to the elements? They still think they can get them?
They believe they can still fulfill them.
Okay.
So their final offer is 35,000.
See, that's the minimum with
Plus 5,000.
the 25,000 minus 60. 60 minus 25 is 35. So that's where we break even in this process, even if we do go to litigation, but might as well get a little more to make it worth our time.
Okay.
But I'm going to bring, so you're rejecting the offer?
Yeah.
Okay. I'm going to bring, after this, I'm going to bring them back in.
That's fine.
Yeah, let's go ahead and bring him in.
I think like, they gotta come up a little. You gotta give them just a little. Like 37.5 is good. I'll take that.
Okay.
So I'm going to bring them back in, and then I'll let you, I'll let them state their claim. And then I'll let
That's
you-
fine. We'll leave this one to you. Save the claim. For me to take it.
Well, most of the offers were rejected. But I believe you two wanted to address each other, so I'm going to start with your party.
Okay, I mean, my client offered you guys 35,000. I'm not really willing to go above that. I'm not sure what your final,
That was our final offer.
the 35?
Oh, no,
Oh,
no,
the
the,
45?
Their final offer was 45.
Our final offer is 35. I mean, I'm not sure what else you guys want from us. We already paid you, my client paid you 70 grand. All you did was run the company into the floor. But, do you want to say anything?
No, I mean, basically, you know, I've already paid him $70,000 in salary for essentially what turns out to be nothing, and I've invested a lot of other money in the business, and the amount of money I'm gonna be losing by trying to sell all this business equipment that I'm never gonna use again, I'm gonna take a big loss on that. You know, I think 35 is a very good offer, given what's happened with the business, that there's nothing to show for any of it. So, you
We
know,
also think we have a good case with the 4 elements of termination for cause. I know you guys are arguing that the intentional prong might not be met, but Joey did.
I don't think that any of the elements would be.
I mean, I think we have a pretty good case. I think that you have a point that the intentional conduct is a little bit up in the air, but Joey did know what he was doing. He took the risk on his own. He failed to even bring it up to my client. So, I mean, if you want to drag this out in court, I think we have a good case.
I mean, I think I was hired to do a position, and I was director, and I was hired with the responsibility to set up the laboratory, secure the necessary state license, and run the laboratory, and run the laboratory being almost the key phrase there, as well as set up the laboratory. So I think that by no means did I have to engage with Dr. Idea in making sure that we could get $25,000 more. I was told specifically to spend no more than $250. So that's the reason the business failed. It wasn't any intentional conduct on my part. So
Which my client
I
even
think there's
appealed.
no way. Yeah, I mean, yeah, we filed
There's
appeals
no way you'd
to,
be able to prove
to try.
intent. There's too many facts to the opposite that we would bring in.
So that's why I think 35 is still a little low,
Absolutely.
considering that 60. You know, we're trying to be reasonable here to avoid litigation and the cost that both of us would incur, legal fees for litigation to get. But I still think 35 is below what I'm at.
I mean, I've been doing this a very long time, and I mean, there's so many things that we could argue for the opposite of that my client, you know, there's no possible way you can prove that he intentionally ran the company to the ground. That doesn't even make sense. As far as the money that you've already paid, that's dictated in the contract. That's his salary. You have to think about these things when you sign a contract. Unfortunately, the business didn't work out. That's no fault of my client's. He still owed what was dictated to him in the contract.
I mean, the business failed because of your client's actions. I don't think
The
it's
business
no
failed,
fault of
let's
your
talk about why
client.
the business failed. The business failed because your client was unable to meet the statutory requirements of the state of Ohio.
Which you hired your client to meet. Your client
I
agreed to
mean,
do
we can
it.
talk about it in court, but
We can.
let's be real.
But I was given a strict budget of $250, and the statutory requirement for cash alone was $100,000.
Right, but you didn't address my client
You
to
never
see if
told
he
me
could
that,
have
Okay,
raised the
okay.
extra money.
you never let me know of
You
anything.
never asked him.
I know what I'm saying. All I was left with
Once
was
it failed is when you told me.
We were only left with
All right,
$30,000 to
Calm
get
down.
the business off the ground
That's
here.
true. It's abide by the meeting.
I believe we're at an impasse right now. Do you two think a resolution can be made today?
My client wants to offer 35,000. Is there anything else you'd like to offer to them?
No.
One second. We'd be willing to take an offer of $37.50. That's it. If not, we're going to court.
I'll let them know.
Wait, what do they say, 37,500?
3750.
And then this will be settled. Your client will go back to Chicago and my client will,
I mean, it doesn't matter what my client will do.
there'll be no further litigation. There'll be nothing going on between these two.
That's what an agreement means, yeah.
If you don't take it in 10 seconds, it goes up 2,500 more.
No, that's not
I'm not gonna be,
Let's be a little bit
intimidated
less
here.
reasonable here.
All right, so is that the final offer?
So the final offer is what, 37.5?
Correct.
I would take that.
All right.
Okay. Sounds good, nice working with you.
It's, nobody's gonna do
Yeah, 200, yeah.
Okay.
25, unless the guy's just.
So, I think we came to an
Pay
agreement.
another 25.
Yeah, certainly, I think we did.
All right, well, I wanna thank you all for coming to mediation and, getting your problem resolved. Before we go, I have this form to fill, and all four of you are gonna fill it out. And I'm gonna write in the terms of the agreement, and I'll fax you a copy later today.
Great.
Your party number one.
I think this is good, we can put this all behind us.
Move on with their lives.
Yeah.
Thank you.
Thank you.
How long did it take, 45 minutes?
Around that time.
Oh, shit. Yeah, 40.